Thank you for joining us. We are excited to connect you all with Nicholas Yuva. He manages the Department of Commerce Landlord Mitigation Fund, and we are going to listen to his presentation and then do a question and answer afterwards. And please make sure to type your questions in the Q&A feature. And I'm going to hand it over to Nicholas. Thank you for joining us today.
Thank you, Alexis. So most of the questions may be answered as I go through the presentation. So do hold on to your questions, and we'll get to any that didn't come up in the slides or in my presentation at the end. I'll let you go ahead and share the screen.
I think you should be able to share your screen now.
Oh, am I sharing on my end?
Oh, sorry. I can. I don't know that I have the PowerPoint.
Oh,
Figures, I'm sorry.
no, that's fine. I have it on mine, so I can certainly do that. Let's see here. There we go. So today we're going to talk about the landlord and tenant relief programs available through the Department of Commerce. What I would like to point out is that we do have the COVID relief program closing tomorrow. So we're going to be in a position where we're not going to have the ability to help folks if they don't have certain things in place already. But I'll talk about that as we get to it. Department of Commerce offers several different forms of subsidies and programs, grants through all of these different departments. The housing and homelessness portion takes up about 25% of our portfolio. And in that housing and homeless portfolio, that's where you'll find the landlord mitigation program. Something that's really important whenever a landlord is applying to the landlord mitigation program is that you're required to have what's called a statewide vendor ID. That ID number permits us to pay you through the state of Washington. So it's not an EIN, it's not a TIN, it's something you'll have to go out and actually get on your own through the Office of Financial Management. The link is here on the webpage. It's also on our sites. And I put a link in the chat to our webpage or our landing page, and I'll go over that landing page once I finish the PowerPoint presentation as well. But all payees in the state of Washington are required to have this number. You'll receive payments based on the preferences when you register for your statewide vendor. So you'll either get it in paper check through the mail, or you'll get it electronically deposited. And that's actually the preferred route. We've had a lot of checks returned to us, especially if you have a DBA or a doing business as name in your registration. So if you prefer a faster, more guaranteed payment, set up the electronic deposits on that. You only need one statewide vendor number, though talk to your accountants, your bookkeepers. They may want you to have a separate one for each individual property or each individual owner. Whatever they want will make it easier at the end of the year when they receive their 1099, so they don't have to go back through and account for every single claim that came through that way. They can just separate out the 1099s at the end of the year. Today, we're going to talk about the 4 programs offered by the landlord mitigation portfolio. That includes the damage relief program, the tenancy preservation program. We are going to touch on the COVID relief program. But there are very specific things you have to have in place to be able to file before that closes at the end of the day tomorrow. And then we're going to talk about a new program called the Survivor Relief Program that's becoming available this summer. All of these are funded through legislative appropriations, and that's based on the need. So they'll poll us every year to see how much money we need, and if there's enough available, they'll give us an appropriation. Document recording fees, that's we get those on a monthly basis throughout the state of Washington. Right now, that's working out to about $4.2 million per year. This year's legislative budget has afforded us $27 million, and that will cover a large portion of the backlog claims in the COVID relief program, but will not cover them all. Again, we'll touch base on that in a moment, but that will pay a lot of folks when we receive those funds in July or August of this year. Now, the landlord mitigation programs do prohibit the landlord from pursuing legal action or collection action against a tenant for damages that were accrued at any time and unpaid rents from March of 2020 through December of 2021. It's important to note that that period of time is the same eligible period for the COVID relief program. Those rents are protected when you do receive funding from this program. The first program is the oldest. This started in 2018. It's the damage relief program. It was the original landlord mitigation program. Legislators have added programs to this portfolio, so we've had to change the name to avoid confusion. This program gives two different types of awards to landlords. The first being when a landlord fails an HQS inspection. So when a subsidy provider comes in and inspects the property, they fail it for material deficiencies. The landlord takes time to make those repairs and then moves the tenant in after passing a subsequent inspection. That landlord could then apply for up to $1,000 and up to 14 days of unpaid rents. That doesn't even affect the larger portion of the mitigation program or the damage relief program. The larger portion is up to $5,000 for repairs made to damages caused by the subsidized tenant. This can be in the unit, it could be in the common areas, but it has to be attributed to a specific tenant that's received a rental subsidy. So unpaid rents, utilities, and other charges can be included once the tenant has vacated in this program. This is not a rental subsidy, so you can't claim unpaid rents while the tenant's in place, but you can claim them once the tenant has vacated on this program. Lease break charges and other rent responsibility, and basically anything that's cloaked in as a penalty for terminating their lease early. Those are non-eligible items in this program, so you won't be able to pick those up, but the program will pay through the last day tenant occupied, the rents through the last day the tenant occupied the unit. Those damages, they'll also pay utilities, whether they were charged regularly during the tenancy or else you received a single bill from a utility provider. They'll cover legal costs, attorney costs, court costs, just not those lease break charges. Again, most of those you cannot accrue until after the tenant has vacated the rental unit. Now, all payments come directly from the Department of Commerce through the Office of Financial Management. They'll be sent directly to the landlord, doesn't go to the tenant. So again, that's however you set up your statewide vendor registration is how you will receive that payment. And right now it takes about 5 to 6 weeks from the time the claim is approved for you to receive payments out of the damage relief program. This is a little different on the other ones because the other ones, this particular program has priority spending on the available funding. The Landlord COVID Relief Program, this has been a huge program for Commerce and the state of Washington, landlords throughout. Landlords can receive up to $15,000 for unpaid rents from March of 2020 through December of 2021. This program is closing tomorrow. We've got a couple of reasons that we've had to close this program down. First off, we cannot issue payments for at least a year from the time that the claim is approved with the claims that we've already approved. With the funding that we received from the legislative session, again, that's $27 million, but right now we have $42 million in approved claims in this program. We've been paying a portion of that, but we're still going to have a substantial number of claims that are going to sit pending payment for quite a while. Also, this program can no longer protect tenants from eviction as the eligible period ended December 31st. So folks are still filing claims for those rents, but they also have unpaid rents for 2022 that this program cannot cover, and therefore the landlords are able to pursue eviction. So there's no benefit to the tenant at this point in this program any longer. This program does only pay for rents, and that's defined as a regular recurring charge. So yes, you'll have your rent in there. You might have a garage rent. You might have fees that you charge every month. Those are all eligible. If you charge utilities through the tenant ledger, and we can see that reflected in the ledger, you can even include those. If you receive a bill back for the utilities, we cannot include those. You'd have to wait until the tenant vacates and apply to the damage relief program if that tenant received a rental subsidy to get that covered. And then the tenant must have voluntarily vacated the rental unit. So if your tenant has vacated and you have your statewide vendor number, you basically have today and tomorrow to submit a claim. I'd recommend doing so immediately. But if the tenant's still in the rental unit, you need to have a defaulted repayment plan. That repayment plan must meet the requirements of Senate Bill 5160, which means the tenant has at least 30 days until their first payment's due. They're not in default until 30 days after they've missed a payment. And then that payment cannot exceed 1/3 of 1 month's rent, and there cannot be a condition such as the tenant agrees to vacate immediately upon missing a payment or something like that in the plan. But if you don't have a repayment plan, or you have a repayment plan and the tenant hasn't defaulted on it, we can't get you qualified for this program before closure. But if you do have a qualifying repayment plan and the tenant's defaulted, they've missed a payment by at least 30 days, again, submit your claim today or tomorrow, or else we cannot accept it after that. The Tenancy Preservation Program, this program is going to become more and more popular. It's important to note that this does not have priority spending, so payments are planned to take longer than a year to receive, though we will receive guarantee of payment. But in this case, the tenant's taking out a zero interest loan at court when the judge finds them to be low income, limited resource, or in a financial hardship. This is really the best program to avoid eviction and to guarantee funding to the landlord for all unpaid rents or other charges that have accrued. This program pays the entire amount on the judgment. It can pay up to 3 months of future rent that has to be included in the tenant acknowledgement letter when you submit. And that's a form that's available on our website that the tenant and landlord sign, both accepting their responsibilities of the program. Now, I did mention this is a zero interest loan. Commerce does not take out collection efforts, but if the tenant does not repay the amount, they're not going to have the ability to use this program again in the future. That's the strictest and worst thing that will happen to them if they don't pay it back. All payments will be made directly to the courts by the tenant if they do make the payments back. The tenant will remain in the rental unit. Again, this program does cover through the judgment and up to 3 months of future rents. So those portion of rents you could not use in a future eviction. As I mentioned, it will take up to a year to receive payment. You'll receive a letter of guarantee. It's up to the landlord to choose to accept that letter of guarantee and dismiss the eviction, or else to go ahead and let the stay action run out after 30 days and evict the tenant, at which time their claim becomes invalid. So it's kind of important. If you want the money without having to go through the effort of getting another judgment and going after collections, and you'll get the full amount rather than having to pay a collection agency, this is a fantastic way to do it. Hopefully the tenant can continue to pay in the future months, and you can maintain them for that period of time while you're waiting for the payment.
Public record disclosure. So all of the information that's provided for the purpose of this program will be protected through the Department of Commerce. So what we're looking at right now, we're still ironing out some kinks in it, and I'm sure we'll have to after the program launches, but we'll be asking for a self-affidavit from the tenant that's notarized, or else a copy of a restraining order, police report, something that's fairly easy for someone to get that's in this situation. We don't want to make it difficult or challenging to have access to the program, but in these cases, we will definitely want to see some sort of documentation to substantiate the claim. Now, the one catch with this program is, and this will come up and it has come up in questions during legislation, was what happens when it's a roommate situation and one party wants to leave. In that case, we can't assist. This is only in situations where the leaseholder is leaving. There are no other tenants attached that are remaining in the unit. Now, if for instance, a family is vacating for this situation, that's fine. We can certainly approve that. But when the unlawful act happens in the unit between parties of the lease, we're not going to be able to assist. So please keep that in mind. And then how long does it take to get claims reviewed and paid? Well, we talked a little bit about payment timeframes, but the review process is pretty simple. Right now, it's certainly a little difficult to get through all the claims every day that are coming on the COVID relief program. we're getting over 150 claims a day right now as folks are trying to get those last minute claims in before we close. But typically we can review a claim within 3 to 5 business days on any of the programs. Oftentimes it's much faster than that, but you'll get a response as soon as we finish reviewing your claim. If it's approved, fantastic. You don't have anything else left to do. You'll just sit back and wait for that payment to arrive. In the damage relief program and when the survivor relief program launches, you can expect that payment within about 5 to 6 weeks. The COVID relief, if you're waiting on payment on that, or the Tenancy Preservation Program, you should not expect payment for at least 1 year from the time that the claim is approved. You will receive an automated email once that payment's approved to issue, and you can expect payment within 2 to 3 weeks of that time. So, now, claims that are denied, you'll receive that notification just like you would after we review any claim. The next question is, what happens if that claim, can I appeal that denial? Really, we'll work with you a bit to see if we can change that from a denial to an approval. Usually it's just missing a document, or we need clarification, or we need some invoices, something along those lines. And it's really easy to change a denial to an approval or even an adjusted approval. The adjusted approvals happen most often because of, in the damage relief program, because there's carpeting involved and we have to prorate the carpet. So that's usually the number one reason for adjustment, or else there's rents or fees that aren't eligible in the program that we have to back out. We just need you to approve the adjustment before we can issue payment. So if you do get an email saying your claim is adjusted, you're welcome to go ahead and ask us for more information. We'll provide quite a bit in the email, but if you need further clarification, that's fine. Go ahead and ask us. If we made a mistake, we'll be happy to adjust it in your favor, but we just need to be able to know that we need to be able to back that up with some documentation. With that being said, if the claim is denied for a reason that we can't get over, like you didn't get a move-in condition report for that damage relief claim, you don't have the notarized statement from the tenant for the upcoming survivor relief program, or you don't have an effective repayment plan that meets the requirements of Senate Bill 5160 for the COVID relief program, we really can't do anything about that. If the documents don't meet the requirements of the program, your claim will be denied. You're welcome to submit a new claim when you are eligible in the future, but ultimately, a flat-out denial, the only way to get over that is to get a judgment in court, which we don't encourage you to do. You're going to spend a lot of money to find out that they're pretty much going to be looking for the same stipulations that we are. But that being said, there are opportunities. And also, I wanted to open up one other thing, and that is going to be the COVID relief program, as well as the landlord mitigation site. And while I'm doing that, let's just go ahead and start loading up some questions in the chat there that we can go over.
Okay. Are you ready to answer a couple now, or did you want to wait?
No, I'm perfectly happy to answer now.
Okay. So if they refused a repayment plan, then what?
Well, I'm sorry, can you repeat that?
If they refused a repayment plan, then what happens?
Well, Commerce can't assist if you don't have a defaulted executed repayment plan. So your next step is really to contact the Dispute Resolution Center at your county superior courthouse. And in doing so, they will attempt to get a repayment plan in place with the tenant. If the tenant continues to refuse to communicate or else even refuse a repayment plan, then the DRC is supposed to give you a certificate which allows you to proceed with your eviction for non-payment of rent. It's an unfortunate situation in that case, but if the tenant's not willing to do their part, which was required under the Bridge Proclamation by entering a repayment plan or seeking rental subsidy, then Commerce can't assist in recovering that debt for you.
Thank you. And are you ready for one more? Or did you want to?
Sure, yeah.
Okay.
Keep coming.
Senate Bill 5160 requires reasonable payment plans for all tenants and originally said before collection account. The Department of Commerce website says that a payment plan is not required for a past tenant. Which is correct? Is a landlord required to offer a payment plan to past resident prior to collection action?
Those are two separate pieces. So the collection action is the order if you want to pursue collections. If you're coming to Commerce, we require the reasonable repayment plan when the tenant's still in the unit. But if the tenant has vacated and you want to file a claim, you don't need the reasonable repayment plan. We'll require a move-out letter to verify that they vacated the rental unit. But that waives the requirement for the repayment plan on the COVID relief program. Any other questions?
Oh yeah. So this is a kind of a question. So COVID relief is for tenants that moved out, it seems. Is that correct or incorrect?
Not totally, no. So you're still looking at the screen here. The COVID relief program is for tenants that are still occupying the rental unit but have entered into a reasonable repayment plan and have later defaulted by not paying on that repayment plan as agreed. So when that happens, you can then submit the claim to the program. And again, I'm going to remind everyone this closes tomorrow. So if you have a reasonable repayment plan, the tenant has not honored and they missed a payment by at least 30 days, you can certainly submit a claim to the Landlord COVID Relief Program while the tenant's still in the rental unit. If the tenant has vacated, again, you don't need that reasonable repayment plan to qualify for this program, but we will need a move-out letter that you would send the tenant within 21 days of the move-out to validate the move-out occurred. And of course, the ledger will have to match up to that as well. We have some document requirements in here. Not too many. This is really about the easiest program to apply for in the landlord mitigation portfolio. So again, we'll need the written rental agreement. We'll need a ledger. We'll need the security deposit disposition letter if the tenant's vacated the unit. If they have not, then we'll need that defaulted repayment plan.
Thank you. So if the expiration date is tomorrow, will landlords still have to submit payment agreements going forward?
Again, these are two separate things. The repayment plan requirements and DRC requirements are separate from the COVID relief program. This is just a program that was born in the same bill, but the program has again outlived its usefulness and its ability to repay everybody in a timely manner. So we are going to be shutting this program down. Again, you'll still have to follow the guidelines set forth by the Senate Bill 5160 with repayment plans, the dispute resolution centers, and of course, the requirements that still continue to persist from the eviction moratoriums and the bridge moratoriums. Now, I know a lot of those protections fell off at certain times, but some of those protections will last until 6 months after the end of the emergency health period. So it's important to be familiar with all of those parts. And again, they're all separate, different cogs in the machine, so they may not exactly work well together with the other programs.
Thank you. And we have a few more questions. Is it okay?
Mm-hmm.
Okay. If the tenant does not pay the funds back to Commerce, they cannot access the funds in the future, but the program expires after tomorrow. So there's no reason to pay back amounts since no one will be accessing the program since it expired. That was a comment, I think, more than.
Yeah, I think we'll try to pull that one up here. So, is that in the chat or in the Q&A?
It's in the Q&A, and it's 2 questions down. At 12:44, it came through.
No, it must have happened while I was fighting the internet. I'm not seeing it on my end.
Sorry.
So,
okay.
no, it's okay. Again, I'm just going to stress that this program is separate from the other pieces. So when this program closes, it does not impact the other programs. For instance, the Tenancy Preservation Program, which is the one that requires repayment. The COVID relief doesn't really has no impact. There's no repayment required there. The Tenancy Preservation Program will continue to persist. The Damage Relief Program will persist. And of course, the Survivor Relief Program will launch this summer. This is just one program that's shutting down in the portfolio.
Thank you. Let's see. Our tenant has refused all communication. How can you prove repayment plan was attempted, but there was no communication from the tenant?
Now, again, if the tenant hasn't communicated, they haven't executed or signed a repayment plan, it's not going to have any impact on the COVID relief. You're not going to be able to apply for the COVID relief program. Your next step is to contact the dispute resolution center at your local superior court and begin the process there.
Okay, what are your options if, oops, hold on. What about a tenant who died in his unit end of last year and we had $15,000 in biohazard cleanup? Can we file a claim for the money lost?
Well, the biohazard cleanup would be considered damages. So if the tenant received a rental subsidy, then you could apply to the damage relief program. If the tenant passed away owing rents, then you would treat it as a move out. We would still need a move out disposition letter. I know that sounds kind of pointless, but we need to have that on file. So if you do that, then you could potentially claim unpaid rents on the COVID relief program if you can get the claim in today or tomorrow. But again, the damages are only going to be covered under the damage relief program if that tenant received a rental subsidy.
Thank you. I think you kind of answered this one before, but what are your options if the tenant refuses all communication and you don't have a repayment letter or a letter saying they've moved out?
Well, now the move out letter, and this question comes up a lot on our claims. The move out letter is the letter that a landlord sends to the tenant within 21 days of move out. It's also called a deposit disposition letter or a final accounting letter. It itemizes all the charges the tenant's responsible for and how the security deposit was applied towards those charges. This is a requirement under Washington state law. Whenever you collect a security deposit, you have to send this letter out. So if you don't have that letter, that's really on the landlord at that point. They need to produce that letter, send it out to the tenant, as well as keep it on file so that they can submit that with their claim.
Okay, if you know that the tenant is refusing to pay and has caused damage, she is not listed as low income, but how can we get help?
So again, if the tenant's still occupying, you have to have that repayment plan. If they've moved out, then you would want to file a claim on the COVID relief program. Now on that program, you do have to attest that the tenant was low income, limited resource, or under financial hardship. So you're going to have to use your best judgment to determine which one of those qualifying factors the tenant falls under. We don't require documentation to prove that. There's no certification that's required on the tenant. You're just attesting under penalty of perjury that that is the truth.
And I think we had somebody with their hand up a while ago. Let me see here. Nope, they're not there. If you had your hand up a while ago and you still have a question, please raise your hand again so we can call on you. Let's see here. Can the landlord issue a move out letter if a property is declared abandoned without a forwarding address after they have moved?
Yeah, what you are supposed to do is send it to the last known address, and that may be the abandoned property. The hope is that the tenant put in some mail forwarding at the post office and that they'll receive that letter. As long as you do your part of sending that letter to that last known address, you've done everything you can. You've done your due diligence. So even if you don't have a forwarding address, you can still send out a letter to send it to the last known address, which again may be that rental property.
If you just have damages in a subsidized unit and has paid rent, can you file a claim after move out at any time?
Yeah, as soon as that tenant moves out, you can file a claim. Now, if you're looking for damages, we will need to see invoices. The damage relief program is a reimbursement program, so we're only going to pay up to $5,000 when we know that that amount has been paid for those repairs. If you're looking for rents on the COVID relief program, yeah, I'd say get in there and file that claim immediately.
And that is all we have so far. And
all right.
question and answer.
Well, and early on, I put a link to this page in the chat, and I'll do it again since I lost position when I dropped the internet. But this website has everything you'll need to get these claims started. You can go to any of the claim pages. Now, again, the COVID relief, you're not really going to have time to get a statewide vendor number. It takes about 5 days or a little bit more to get that back. But if you need to get your statewide vendor number, you'll find the links on the web pages. They'll direct you over to the Office of Financial Management, and you can begin your application here. Now, again, that takes about 5 business days. So if you don't have one, you're not going to have it in time for the COVID relief program. But you should certainly get one now, even if you don't have any other claims to submit on the damage relief program, the Tenancy Preservation Program, or the upcoming Survivor Relief Program. It's good just to have it handy and ready to go whenever you need it. But if you have any other questions, my our email's on the web pages as well, and so is the phone number. So I will say emails, you'll get a faster response over email right now. We're very, very busy, so phone calls do take a few days to get back. But happy to answer any more questions you might have in the future.
We actually have a few more questions.
Sure, yeah, go ahead.
But yes, I recommend all housing providers apply for the vendor ID number just in case they need to, utilize the funds. Okay, so is the 5,000 for damages per tenant for their lifetime or per incident?
It's a good question, and one that comes up. It's per tenant household relationship. So basically, as you have a tenant household and you're making claims on it, you can make multiple claims. The minimum claim is $500, so you can do 10 $500 claims throughout the lifetime of that tenancy. Once you hit $5,000 for that tenancy, you cannot collect any more, even if you transfer them to another unit. But if that tenant moves out and goes to another landlord, they can have access to another $5,000. So even if your tenants have gotten reimbursed through the program in the past through a different landlord, you can still have access to these as well. So yeah, it's per tenant household with a $5,000 cap.
And then there's a really good question in here. All of them are really good questions, but I can actually help answer this one a little bit. Should pictures be submitted to the Housing Authority or Department of Commerce? And we ask that you send us pictures and the move out statement if there are extreme damages, but also you're going to probably have to submit them to the Department of Commerce as well if you're submitting a claim. Is that correct, Nicholas?
I'm gonna go back and say, hold on to your pictures. We may need them, okay. But don't submit them with the claim because we can only take 10 attachments on our claim form. Focus on the documents first. We will ask you for photos if we need them, and typically it'll be extreme situations like you had to replace cabinets, appliances, bathtubs, stuff that you wouldn't normally do on a turn. Normal stuff, we just want to see the invoices. Painting, patching, carpet cleaning, carpet replacement. We will require invoices for the previous carpet as well as the new carpet, unless you were smart and you had the tenant put new on the move-in condition report. We'll count that as proof of age. But aside from that, we're only going to ask for photos if there's something that is not a normal part of a turn that's a fairly extensive repair.
For some unknown reason, my MAP does not submit my mitigation damage form and supporting documents. Is it acceptable to take photos and submit everything via my phone?
You can, and actually, I'm going to push this. There's an app in the for the Android users out there. There's an app that I got for my phone that I absolutely love. It is called CAM Scanner, so CAM Scanner. With this app, you can take a picture of a document and it'll convert it to a PDF scan. It's a free app. I love it to death because you can actually take multiple pages and have it all convert into a single file. So if you use that or something similar, you can certainly submit your claim on the phone. But if there's an issue with submitting claims on your computer, there are two reasons that's occurring that we've found. And I can recommend that you just simply clear your cookies on your internet browser settings, close your browsers and then restart the browser, and you may actually be able to submit the claim. The other reason is that your attachments are just too large. There is a size limit to the attachments. So if you're putting massive files in there, it's not going to allow you to submit. So yes, you can do it on your phone, but also try to clear your cookies and make sure your attachments aren't too large, and you shouldn't have any problems.
Thank you. Okay, a few more questions. Does the move out letter need to be certified mail, or will regular mail do?
We are picky on our end, so really, as far as the law is concerned, just as first class mail. We don't even need to see proof that you mailed it. We just want a copy of the letter for our files.
And then we've got a couple shout outs for you and your team from a couple of our housing provider partners. So a plug for Nicholas and his team, great communicator and quick turnaround time. Thank you very much, Nicholas. And then another housing provider also said, I've gotten $5,000 for a past Section 8 tenant through the damage relief program, and it was great and easy. So thank you.
It's my pleasure. I know that folks that may not be technical, I can't even say it, are good on computers. They have challenges, and we do try. We are very busy right now, but we do try to reach out and respond to everybody. And our goal is not to get too nitpicky on the claims, but try to find ways to approve claims. So if we're reaching out to you or we're denying your claim, we're giving you exactly what we need to approve your claim in those responses. Sometimes we just can't approve them, and we, that's unfortunate, but we will certainly give you all the information so that you can get that denial turned into an approval. We get some money out to you. Well, if there are no more questions, I want to thank everybody for attending, and stick around for the next symposium. I'm going to give you some time back, unless Alexis, you have anything else you want me to cover?
I just want to thank you so much, Nicholas, for joining us the day before one of your big programs is closing. I really appreciate that. And you have always helped us out in doing the symposiums, and you're answering a bunch of questions earlier in the Q&A. So I know from all of us at all of the housing authorities, we thank you for presenting today and joining us, and for all of the hard work that you're doing.